What should you do after a patent application rejection? Imagine spending months or even years developing your invention only to face a rejection from the patent office. It can be frustrating, but it is a common part of the patent process. So, what are your options after a rejection? Let's walk through the steps you should consider to keep your patent journey moving forward. First, carefully review the office action issued by the patent examiner. This document explains why your application was rejected. It often points out issues related to patentability requirements, such as whether your invention is new, non-obvious, or sufficiently described. Understanding these reasons is key to figuring out your next move. If the rejection is based on issues you can fix, like clarifying your claims or providing more details, you should prepare a response. This might involve amending your claims to better define your invention or submitting arguments that explain why your invention meets patent eligibility standards. For example, if the examiner says your invention is too similar to existing patents, you can revise your claims to highlight unique features that make your invention patentable. Sometimes, after 1 or 2 responses, the rejection remains. That's when you can consider filing an appeal with the Patent Trial and Appeal Board. This involves submitting a notice of appeal and an appeal brief that clearly states why you believe the examiner's decision is wrong. It's important to include legal and technical reasons that support your case. Before or during an appeal, requesting an interview with the examiner can be very helpful. Talking directly with the examiner might clarify misunderstandings or lead to a resolution without going through a formal appeal. Be prepared to explain your invention clearly and address any concerns they have raised. If the appeal is unsuccessful and the rejection is upheld, you can pursue further review by asking a court to examine the case. This is called judicial review and is done through the Court of Appeals for the Federal Circuit. It's a more involved process but can be an option if you strongly believe your invention is patentable. Throughout this process, working with a patent attorney can make a big difference. They can help craft strong responses, prepare appeal briefs, and navigate the legal procedures effectively. Their expertise ensures your arguments are clear and persuasive. In summary, after a patent application rejection, start by analyzing the reasons carefully. Respond with amendments or arguments if possible. If rejected twice, consider appealing to the Patent Trial and Appeal Board. Request an interview with the examiner to clarify issues. If needed, pursue further legal review. Following these steps aligns with patent law and helps protect your invention's rights.